Hello and welcome. Thanks for joining. Today I'm going to go through the 2023 definitions of working relationships and exclusive right to buy listing contract. These are the two documents that you'll need to sign in order to start working with a realtor like myself here in Colorado on an exclusive basis. What does that mean for you? So with these documents here, that means a couple of things. You're choosing your realtor to work with them exclusively. So you're choosing to work with me on a one-on-one basis. That means I'm exclusively helping you, negotiating for you on your behalf, and advocating for your best interests. Everything that we do at that point has to be beyond our own best interests and in the consumer or the public's best interest. So we'll go through this document. The first one is the definitions of working relationships, and that document says the three different ways that we can work together as you are purchasing a house. You'll notice that it has a fourth section on it for selling a house. It's the same document as you would use if you're selling. So we'll go through those three different ways, and then we'll jump right into the exclusive right to buy listing contract, which is how you hire your realtor, myself, to help you buy your house. Looking forward to helping you in your upcoming home purchase, and I'm excited to get any questions you have, any comments or concerns shared and addressed ahead of time. That way we can make sure we're off to a great start in our relationship and are able to buy you the best house in the least amount of time for the least amount of money. So let's get moving here. First, you'll see on my screen here that we are looking at an email. This is exactly how you will receive the contracts and all the disclosures and contracts moving forward after the purchase agreement is signed. So take a look. We'll see that there's an email telling you that these documents are from the state of Colorado. The attorneys of the state of Colorado did draft these documents, and we are able to perform a limited attorney-client privilege service here as a fiduciary for you to fill in certain areas, certain lines, and certain checkboxes and negotiate on your behalf. So then we have below that there will be a link here to view this video. I'm shooting it right now. So this link will take you to the video about seeing these contracts, whether it is before we've gone through them or after to get a second look. Either way, these contracts are the same. I go through them the same way with everyone, and we want to ensure that there is nothing missed as you are signing this, because I'm probably the same way you are. I don't like to sign things unless I know exactly what I'm signing. So we'll get into it now. The first one is the definitions of working relationships. Notice to open it and be able to sign, I will be clicking the blue link. The blue link opens a signable and editable version. Once it is signed, it's locked and cannot be changed. All right, so this is legally adopted software here called CTME contracts. So we'll click the blue link and we'll get us started. This here is the definitions of working relationships. As I mentioned, there's three ways that we can work together: as a buyer's agent, as a transaction broker, and as a customer. And notice the seller's agent is still up here if you're selling a house. So as a buyer's agent, know that this is a disclosure, right? Before I jump in, this is not a contract. It is just a disclosure that's required for us to go through it before we get to the next contract. So again, starting as a buyer's agent here, this document says that as a buyer's agent, we're promoting your best interests. So the buyer's best interests with the utmost good faith, loyalty, and fidelity, seeking a price and term suitable to you, the buyer, and disclosing any material known benefits or risks of the transaction that we actually know. So again, we're working with your best interests at mind. Your best interest will supersede my own best interest. So if there's anything that is detrimental to me for whatever reason, but it's best for you, that is how we proceed. Your best interest is always taken first and foremost. As a transaction broker, this is how a lot of other brokerages choose to have their agents work with their clients, because it eliminates the risk off the realtor and it adds more risk to you, the consumer. So as a buyer's agent, if I were to make a mistake, even give you a bad recommendation of a vendor, it can put me in serious liability and harm's way. There's massive six-figure fines involved, could even lose our license for a simple mistake. So as a transaction broker, Again, brokerages will choose to have their agents work in this capacity because it greatly reduces the risk and legal liability on the brokerage, and the brokerage is always looking out for their best interest. So if their agents, one of their 1,000 agents or 50 agents, however big they are, makes a mistake, it limits them from liability, because as a transaction broker, you're not negotiating or advocating on your client's behalf. For example, if you ask me, Cody, what price should we offer? What items should we ask for on the inspection? How should we proceed with the appraisal resolution? Any of those negotiating points, I'd ask you a question, kind of like a political response. That's a great question. What do you think you should do? See, you're pretty much navigating the process by yourself. At that point, it would make more sense to hire an attorney who's actually familiar with law. So we work as a buyer's agent because we're putting your utmost good faith, loyalty, and fidelity. We're seeking a price and terms that are suitable to you, etc. We want to work in your best interests, and just know that I am doing my absolute best for you, because if I don't, there are serious fines and repercussions. At the end of the day, I'm here to help people, and that's why we're doing what we do. So that's the transaction broker. And as a customer, we look at that similar to going to the grocery store and checking out. There's very little responsibility on the customer, on the realtor, to do a great job, because they're not advocating for you. They're not negotiating for you. They're saying, here's a line, it's empty, it needs to be filled. What should we put in there? And then you respond based on what you think. And the realtor's not going to say that's a good move or a bad move. They're going to say, thanks, what's next, right? So think of a buyer's agent as in a boxing ring. You've got your coach. It's in the corner, in your corner, saying punch left, punch right, right? They're giving you help every step of the way. Whereas a transaction broker is also just filling in paperwork, making sure it's done and completed. And as a customer, there is no brokerage relationship. So in other states, you can represent both buyer and seller as an agent, which puts the realtor negotiating against themselves. And that is a conflict of interest. So in Colorado, that is not allowed. What could be allowed, though, let's say I was hired by you first, and then I was cold calling or door knocking or something where I found a seller that was unrepresented and willing to sell their house to you off market. That's a great scenario, but I cannot be hired by that seller in a full agency capacity. You've already hired me. And we'll get to the contract where there's an option to change things with your disclosure and permission. But we could work with both parties as a transaction broker and coach up front. We could work with you as an agent and the seller as a customer. There's a couple of different varieties of ways which we would talk about in the moment, have full disclosure and give all parties the right to a full agency relationship with a broker if they wanted. Sometimes it's just not necessary, though. So as we go through this document, again, that is the full description of what everything means in here. And again, it's not a contract. It is just a disclosure. So to you, it would look a little different above your name. I've just plugged in my own here. It would have a big white box. You're going to click select signature font, choose signature, save, then accept when the accept window pops up. As soon as you save it, it will send both of us a completed copy. All right. So now you're done with that one. We're going to go to the exclusive right to buy listing contract. So as I said, this one is a contract, as it says at the top. I've selected buyer's agency. That's how I choose to work with all of my clients to make sure they're getting the best possible service. We would have today's date. We would have multi-person firm checked, as we have, as of the recording of this video, about 87,000 realtors globally at eXp Realty. Before I go any further, I do want to let you know, full disclosure, again, this document is created by the state of Colorado. It is legally binding, and once signed, it would put me, or if you're working with another realtor, put them working an exclusive relationship with you, meaning you cannot hire another realtor unless you want to pay 2 success fees. That's completely up to you. So we're going to go through this. We're going to skip some sections because certain sections will not apply to the average residential transaction. If you're getting this video, most likely it will not apply to you if we're skipping it. You could buy a farm or a pizza shop or other commercial real estate with the same exact form. You can use all different loan types on this document. So there's quite a few pages fully that will be skipped. So now we'll move forward. This is exactly how I would go through it with my clients. So here we have the exclusive right to buy listing contract. As you've noticed, I've selected buyer's agency. That's how I choose to work with all of my clients so that we know we're performing at the absolute best of our abilities and giving you the best service possible. At the top, we have today's date. We are a multi-person firm. Again, we're about 87,000 agents across about 27 countries in all 50 states right now. We have my name below, Cody Walker. We have our brokerage, eXp Realty LLC. Again, buyer here would be your name and broker below would be my name. Then we scroll down to the listing period. Notice we skipped the lease period. The listing period would start today on today's date and end. Currently, I have it set to 9 months. We set between 6 and 12 months as a standard agreement length because a lot of buyers will choose to delay things or might need to repair some credit, and that just allows us to work without having to redo these dates or contracts later. So if you buy a house, this contract terminates, or if you just don't like working with us and don't feel like we're working in your best interest, you can also terminate. You won't be locked in. Moving down to 382, we have computation of period of days deadline. This says that if any of the dates and deadlines were to fall on a weekend or a federal state holiday and the title companies are closed, that deadline would just move to the next business day. Helps everyone involved, and we work to make sure that none of those dates are set on purpose there. Number 4 is the full disclosure that we just went through. And notice I've left blank here the buyer's agency only box. That allows me to prospect off market and find sellers that might be willing to sell off market to you, whether for a convenience or for a lower price or both. So again, some convenience there. And in order to change our relationship or agency status, there is documentation that needs to be fully agreed upon by both parties and signed, so it will never come out of the blue and the situation will always be discussed up front. Going down to section 5, these are all the things I'm legally required to do for you as a buyer's agent. Now, some of them might seem self-explanatory, but there's a few areas in here that are common misconceptions. For example, we will never disclose adverse material facts about you. We will disclose material facts, but we will not be disclosing why you're purchasing. So your motivations, your intentions, if you're moving for a job relocation, etc., things that can help them negotiate against you, we will not share, but the adverse facts we will. So what does that mean? If the seller's sitting in the driveway or talking on the phone, we overhear them or they tell us that situations have changed on their end, or they're going to try and pull a fast one of some sort. Maybe they know of something wrong that they're going to try and hide. They have a vendor out to fix something that they didn't disclose. All of those things, if we see them or hear of them, we're required to disclose to you. All offers will be presented in a timely manner. So even if it's a verbal offer and you say, hey, Cody, do you think the sellers would take 500? Ask them if they'd take 500. You've just requested me to make an offer. And while that's a verbal offer and not nearly as strong as a written offer because there's no reason for them to say yes, I do have to present it, and I have to present it in a timely manner. And timely manner is subjective. So for me, that means if it's super late in the evening, well, what's super late? 7, 8, 9, 10, 11 o'clock at night, and maybe I'm off work for the day, not near my computer. That's going to happen on the next business day if I cannot get to it. If it's in the afternoon, I'm going to take my next available time slot and get to it, send it over to you, and we'll discuss the deadline in which the seller has to respond. Every offer does include a deadline that the seller is required to respond by. If they don't, that means your offer is null and void. If they sign after the deadline and you want to continue, that's okay with the state of Colorado too. Anyways, we do not touch any of your money. So any deposits or down payments, anything that you send in, it goes straight to the title company. It does not get touched by me or eXp Realty. We will not disclose that you're willing to pay more than the purchase price ever. We want to get you the best deal. So unless you tell us in writing that we should tell them something that might be detrimental to the contract price or closing dates, etc., we will not disclose that information. That is private. All right, so those are the main ones there. We'll go down to number 6. Already went through these in the last document, but our job is mainly to promote the interests of you, the buyer, with the utmost good faith, loyalty, and fidelity. Seek a price and terms that are acceptable to you, the buyer, and counsel you, the buyer, as to any material benefits or risks of the transaction that are actually known. Number 7, compensation. This is the only time we talk about compensation. We get paid a 3% success fee, and I have it written in personally that if the seller is offering under 3%, but over 2%, that the buyer is not responsible for making up the difference, and we will accept the success fee that is offered by the seller. In certain rare circumstances, such as a for sale by owner or very rare MLS circumstances, we will know if it's below 2%, and we'll talk to you in advance because in this contract you were agreeing to pay the difference if it's under 2%. And that just allows us to get fairly compensated for all of our hard work. There's over 180 different things going on in the background, and sometimes as much as 85 different people working on the transaction that we're navigating through and helping to make sure you have the best resolution possible. Going down after that, we have the one of 2 sections that protects us. So this says listing brokerage firm or seller may pay, but the buyer is obligated to pay. That's a couple of circumstances. Again, if it's below 2%, that's saying that you'll make up the difference. And that's also saying that if it's a for sale by owner, for example, where they're not offering a commission, that we would potentially work that into the deal where it would be part of the purchase price. We would go through all the math up front and make sure you're not overpaying. All right, Section 7.4, the holdover clause. This says that within 99 days of me negotiating a contract on a specific home, that if you were to terminate with me for whatever reason, and I've submitted this property to you, that I would be owed my success fee for being in completion of our work, right? So we get fairly compensated for our work again. Number 8, limitation of third-party compensation. This says if I recommend you any vendors, a landscaper, a roofer, a mortgage lender, I am not getting compensated by that company. I just think that they're going to do a great job for you. They're going to show up and charge you a fair price. So that's out of the goodness of my heart, and know that even if I give you a bad recommendation and they do something that's detrimental to you financially or in the timeline of the transaction, it can actually come back to bite me in the butt. So we try and give multiple recommendations, but just full disclosure, know that it is just a recommendation. We've either used them or heard great reviews, and we're hoping to help you. In no means do we intend for that to come back and bite you in the butt if something were to go wrong. Of course, there's human error in every part of this world. All right. Number 9, this is saying that you are not currently signed in this agreement with another Colorado licensee, and that they have not submitted a list of properties to you, just as I went over above. Number 10 is the rights of party to cancel. There's reasons that you can cancel as a buyer and reasons that I can cancel as the realtor. So you can cancel if you do not think that I am working in your best interest. If I've waited way too long to communicate with you, that's not 3 hours or even a day not getting back to you. That's like a week if I haven't responded. That means something's really wrong. Please do fire me, or at least check in on my health, right? There's also reasons that I could terminate my relationship with you. Again, if you're going a week or 2 without communicating and we need to hear back for the sake of the transaction, if you're lying to me, or in very rare cases, if anyone is being discriminatory toward the seller or another agent, we just don't tolerate that. So that allows us to exit, but know that I allow my clients the right to exit in writing as long as they're not canceling to just circumvent our success fee. If they just don't like working with us, they don't want to buy a house anymore, they don't think I'm working in their best interests, I choose to work with people that I will enjoy working with and that I know will enjoy working with me. So if something happens and we just can't get through it, it's time to separate ways for you to enjoy your experience and for me to continue enjoying what I get to enjoy doing every day, which is selling real estate and helping people. Number 12, brokerage services. We will show houses at our discretion. So we're going to go through the expectations of showings, what you want, what you don't want, what you need, what you don't need, price ranges, payments, proximity to things, whatever we have discussed is a major leading indicator of what will cause you to buy or cause you not to buy. We will schedule showings based on that. And we typically find that most people find their perfect home in between 4 and 6 showings after going through that consultative process. So we're not going to schedule 10 showings in a day. It's not in your best interest or ours. There's just not typically that many properties for sale either. And if there are, they're likely not matching your criteria. So we'll go through at our discretion and schedule showings. We ask typically that we get at least a day of notice. Sometimes that's just not possible, but know that we're going through a showing service online that goes to the other realtor and sometimes then straight to the seller, back to the realtor and back to us. So in order to give time for planning, people to get out of their house, schedule a babysitter, take the dog for a walk, or move to a coffee shop if they're working from home, we need to give ample time for them to approve or request a reschedule. This below that says that we have access to these MLSs. I have access to RE Colorado and Iris. That covers all of northern Colorado and all of surrounding Denver metro and everything in between. Beyond Denver to the south, there is a third Pikes Peak MLS that we do not currently have access to, as we do not typically cover that service area. Number 13 says that we do have the right to disclose your identity to any third-party vendors. What that typically is a mortgage lender and a title company, and beyond that, probably not anyone else, maybe an inspector or appraiser, but that's giving your permission to do so. Disclosure of settlement service costs, just below that, section 14. The title company is responsible for this. Typically, it's about a week before closing, but sometimes it's just 2 or 3 days or a day before. Any changes can typically be made day of or even at the closing table in just a few minutes, so not a big deal there. We'll just review it and make sure it looks good. Wire fraud is a real problem. We do, especially for buyers, go through another disclosure on this in depth. Just be aware of how you can send money, where to get the information, how wiring instructions come in and don't come in. In your email, for example, they will come through in an encrypted portal, not just in the face of the email or in a PDF. It's likely a scam if it's in just the email that pops up, or if it's in a PDF. It's going to be in a portal given to you over the phone by a title rep that you've likely already spoken to. Any questions about that, call the title company directly or me or your broker. Removal of marketing material. Sometimes you can remove marketing material, but with builders it might not be if they're going to gain access to those photos for future marketing. Non-discrimination. We don't discriminate against anyone for any reason. We'll leave it at that. Recommendation of legal and tax counsel. If you need an attorney or a CPA, that is not me nor my team. We're not licensed for it, but we know people who are and happily will give you recommendations to people that we know, like, and trust. Mediation. Mediation is the free version of going to see an attorney, and it's actually something you're agreeing to do in this contract. So this contract, by signing it, says you'll seek mediation prior to an attorney if you need to go that route. If we need an attorney, whoever is requiring that attorney, we'll definitely go through and hire them. Of course, there are fees attached to it, so the prevailing party is required to pay all reasonable costs and expenses, including the attorney and legal fees. Section 21, we would have additional provisions. They're not typically needed in a buyer purchase or buyer agreement. Here, there are no attachments typically unless you're signing our team, and we would have all of our additional team members' names there because the state says if we're on a team, we share systems and they might get your information. That would not be detrimental to our transaction, but it's just required as a layer of protection. Section 24 talks about how we deliver documents. We use this program, CTME or DotLoop or DigiSign with our clients, one of 3 different DocuSign type electronic signature platforms. All the documents are locked once they're signed, and if a change needs to be made, we would duplicate it. It would delete signatures, and we'll try again. So we use email or text. It says fax here, but I don't know how to use it, so we won't. Modification of the contract, again, is not allowed. There are no counterparts to the contract. This is the entire agreement. You will receive a copy upon signing an electronic document. If you did this in person, then we will scan it and send you a copy once it's signed, but know that we're required by law to keep these documents for a minimum of 4 years, as is our brokerage, as is the title company, so don't worry about saving them on your end. Lastly, we have Megan's Law, which will also include in there the rules behind school districts. There are certain things that we cannot share with you, such as the location of registered sex offenders or felons in the neighborhood, nor can we tell you our opinion on the quality of schools. Those things you can easily Google by typing in Megan's Law or school of choice, Denver schools ratings Fort Collins, schools, ratings, etc. Those things can be found very easily. Unfortunately, we're just not allowed to share that information. If you have no questions, comments, or additional concerns, go through and click Select Signature Font, Save, and Accept. And that would have you sign the contract just like that, get us working for you immediately, and take the next steps towards your home buying goals. We would love the opportunity to serve you and your family in buying your next house. And if we do a great job, we'd love to earn a referral from you of any of your friends, neighbors, colleagues, relatives, anyone that you know, like, and trust that would be a great fit to work with us. And of course, a 5-star review online so that others that are researching us in the future can know how we serve our clients here in Northern Colorado and Denver, so that they too can buy their houses or sell their houses with us. Thanks again for watching. These 2 documents are the 2 that will get us hired to start working for you, and then our transaction coordinator will soon after send you disclosures required by the state of Colorado, which will have additional videos to go through if needed. So thanks again. It's Cody Walker with Source Home Group at eXp Realty. These are the 2023 contracts to help get us hired to work for you and make your home goals happen. Thanks again. Have a great day, and we'll talk to you soon.